Sit back, relax, and now we're going to have a history lesson. In 1923, the United States Supreme Court heard the case of U.S. v. Fry. Mr. Fry was a defendant who was charged with, I believe it was robbery. In 1923, lie detector technology was very, very new. And the defense, Mr. Fry, called an expert. And this expert was someone who went to school as a psychologist and had gotten his hands on a lie detector. And he started using it in his work. And he was brought on by the defense attorney, and he subjected his client to a lie detector test. And in that lie detector test, the guy that administered the test asked him flat out, did you rob this bank or whatever it was? Did you commit this crime? The answer was no. Now, if you guys know the science behind lie detector technology, it basically means that it's based on the proposition that by monitoring someone's blood pulse rate and their blood pressure while subjecting them to the stress of questions that they may or may not have to answer truthfully, the theory is that you can detect whether someone's lying by noticing large spikes in their pulse rate and blood pressure. So that's the science behind lie detector technology. Mr. Fry's attorney tried to enter that lie detector result into the results of the lie detector test into evidence, and the judge said no, because at that point, the prevailing standard was whether or not, quite simply, whether or not the science has been generally accepted in that field. Case in point, it was so new there was no field for which it could be generally accepted within. So the answer was simple for the judge. No, it's not coming in. I don't know what a lie detector test is. I don't know who administers this. I don't know what the science is behind it. It's too new. No, it's not coming in. He was convicted. They brought it all the way up to the U.S. Supreme Court. Scratch that. They brought it up to the 3rd District Court of Appeals, and it got struck down there. They, again, agreed with the standard of general acceptance. Fast forward to 1972, and by the way, I just wrote my upper level writing requirement on this, so I'm very knowledgeable on this area. None of this is BS. In 1975, the Federal Rules of Evidence were written, just as you see them here. They were written to impose these requirements, these 3 standards. Testimony of experts has to be based on reliable principles and methods, and you have to faithfully apply those principles and methods to the facts in this case, so on and so forth. If you read it literally, you'll see that there are remnants of this general acceptance theory there. The reason why we're going into this long history lesson is because it's very, very important for you to understand where the law is now. So just bear with me. The whole thing, the thrust of expert testimony is about reliability. Whether or not the science that you're talking about is reliable. It's usually a common sense question. If you have a toxicologist, common sense would dictate that there have been toxicologists for quite some time. We know what the periodic elements are, so it's fine, it's reliable. But nowadays we have psychologists that are testifying to what they call lost memory retrieval, where they put you into a trance and they extract these memories, they subject you to basically hypnosis, and then you relive these memories that you have previously suppressed. Suppressed memory retrieval, I think is what it's called. That seems like hogwash. It's just not reliable. That's why the present state of the law doesn't allow that kind of testimony in. The catch is that it's not disallowed because it's not generally accepted within the field. The federal rules kind of did away with this test of general acceptance. Now it's about reliability. What are the reliable principles and methods, and whether or not the expert applied those principles and methods to the facts in this case. Both requirements impose a reliability standard on it. These rules don't actually, this copy of the rules don't actually have a comment, but I think that, don't quote me on this, but I think that the full version of the rules actually have a comment to Rule 702 that talks about the newest case out of the Supreme Court, which is the case of Dalbert v. Merrill Dow Pharmaceuticals. This case turned Fry on its head. This case was about a mother who was pregnant and ended up taking some sort of drug, not an illicit drug, just a pharmaceutical, and her baby was born with like 3 arms. And she sued. She's like, I got a baby with 3 arms, I don't want it. Not that she didn't want it, but that like she just didn't want it to be like that. So she sued the pharmaceutical company. She called an expert in who ran some tests, and the court again sided with the defense, or in this case sided with the party not calling the expert, but for a different reason. They said that the tests run by this doctor, or this expert, were not subject to peer review. They were not scholarly review, not scholarly reviewed. They were not subject to peer review. They have this, basically they listed a number of factors that you can use in determining whether or not it's reliable. So they still centered on this sense of reliability, but now they specifically tell you there are like 5 or 6 things you can look to determine reliability. At a later time I'll give you guys all the factors and we'll go into those in more detail, but for now, understand that 702 talks about reliability, and the context of that reliability is whether or not the principles and methods underlying the science are reliable, and whether or not this particular expert in question applied those reliable principles and methods to the facts in this case.
So essentially, it could be generally accepted, or could not be generally accepted, as long as it's reliable. Like, you know what I'm, then it's allowed in. Like
well, one of the factors is general acceptance. So the court didn't completely do away with the Fry standard. There's still a sense of it. So, and they're not strict factors. It's not a checklist. So if every doctor is willing to testify that this is the way you do an operation, then it's generally accepted. That's probably going to override whether or not it was subjected to peer review. It's a balancing.
Okay.
So although basically it just means that now, I mean, it arose from a need to have rules regulating experts, because before you could just have an expert in anyone, and you could be an expert in anything. So now we need reliable experts, because people call experts all the time now.